Next up, we have 18-1711, Benjamin Roy versus State of Florida. And if council will just give me a second to reset the clock here. Okay, council, how much time would you like to have in rebuttal?
Good morning, Your Honors, and may it please the court. My name is Andrew Greenlee. I'm here on behalf of Mr. Roy. I'd like 5 minutes, if it pleases the court.
Okay, whenever you're ready.
Thank you, Your Honor. Your Honors, this is an appeal about authentication of documents. Authentication requires under 90.901 that the proponent provide evidence sufficient to support a finding that the matter in question is what the proponent claims.
And so if we talk about the text messages, the law enforcement officer testified that he was the one corresponding as the 14-year-old or the purported 14-year-old child, correct?
Correct.
And that he was corresponding with someone by the name of Bonji Roy.
That's inaccurate. It's not in the text messages. There's nothing about Bonji Roy in the text messages. So that is from the Gmail chat, what we refer to as the Gmail chat.
Okay.
That's where the Bonji Roy comes in.
Well, that's where the phone number was transferred, correct?
Right, right.
Okay, so the two are connected.
Well, they're connected, but I think that each piece of evidence has to stand on its own. You know, when you're introducing a document, I don't think that there's...
Well, it's clear that circumstantial evidence and extrinsic evidence can be used to help authenticate a document. You would agree with that, correct?
Circumstantial evidence can be used. Yes, that's correct.
Right. So you have the police officer that's testifying to his initial communication. He puts up the Craigslist ad. He gets a hit. Somebody responds to it. They begin to correspond. That's where he gets, I guess, the Bonji Roy.
Right.
And then they then begin to communicate by text message. Mm-hmm. And so whoever it is that's claiming to be Bonji Roy provides a phone number to the detective, correct?
Correct. Then
the detective and this person, Bonji Roy, then begin corresponding via text.
Correct.
Correct. So, and the police officer is telling. I mean, so why is it that the police officer cannot authenticate this message? Now, it could be up to the jury to decide whether or not the person sitting at defense table is in fact the Bonji Roy that was delivering the text. But why isn't that sufficient to establish that the police officer was texting with an individual that was naming themselves Bonji Roy?
Okay, 3 responses. First, it's not his cell phone. So I think that the starting point and the presumption should be that it's not him.
You argued below it was his brother's cell phone. Not you, the
defense counsel, he argued below that it was his brother's cell phone. Mm-hmm. Again, it's not his cell phone, and that the argument of counsel is not evidence.
What's the evidence as to the ownership of the cell phone?
There was none. There was none. There was testimony that it was registered to a Roy. What that means, I don't know. It means somebody with the last name Roy had the cell phone. And by the way, that testimony, it was clear from the context that the source of that was an analyst who wasn't testifying. It was pure hearsay. The trial court judge said he sustained an objection on hearsay. He said this is all hearsay. Because if it's just from, okay, the analyst told me that it was registered to a Roy, then that's not enough. That's the foundation is hearsay. So
there is no record evidence as to the ownership of the phone.
There's no record evidence as to the ownership of the phone.
Why did counsel argue that?
I mean, I think that I can't say why he argued that.
Was the trial court required, even though defense counsel argued that, was the trial court required to disregard it, ignore that argument?
Well, if I could make a slight distinction here, I don't think that he argued that. He questioned a witness. He said, isn't it his brother's cell phone? So it's not really an argument, it's a question of the witnesses.
What was the response for the witness? What did the witness say?
That was where it came up. He said, well, it was registered to a Roy. It was registered to a Roy. But again, if you look at the actual source of where that information came from, it was from an analyst who, by the way, the state withdrew.
So, okay, so you have a defendant named Roy.
Right.
Benjamin Roy.
Right.
You have a correspondence with somebody named Bonji Roy. You have a setup to come meet at a specific location, and an individual with the last name Roy shows up at that location
Right.
in a car that was owned by his brother, correct?
Correct.
Also last name Roy. And you have him fleeing the scene when he's approached by law enforcement. Well, you have him going there, acting strangely, leaving, and then coming back. And then you have law enforcement trying to apprehend him, and he flees the scene.
Right.
They find the car, and they identify him as the person. There was a law enforcement officer identified him as the person that was at the racetrack.
Correct, Your Honor.
And inside the car, they find his driver's license.
Correct.
And so you don't think that that's sufficient to get past a JOA in this case?
Your Honor, I'd like to, if it pleases the court, I will stipulate that if the evidence was properly authenticated, then the JOA was properly denied. Our argument on so I would leave for your Honor's.
And let's talk about the authentication, but because if you can look at this extrinsic evidence, if the cases say you can look at extrinsic evidence to authenticate, why doesn't all of that extrinsic evidence that points to, I mean, you'd have to have a lot of coincidences in this case.
Your Honor,
Why doesn't that help authenticate who it was who was the person who was responding to the police officer?
Your Honor, I'll take that. There's a lot that I need to unpack in that question. First of all, with respect to the Gmail communications and the Bonjay Roy aspect of it, there's no indication as to where that came from, as to whether that was in fact a Bonjay Roy. There was no business record certification. There was no records custodian there to authenticate, to say that these are reliable records here. That's
You just need
typically
the
done.
police officer to testify that he was engaged in the conversation, right?
That's not what Earhart says. I'm quoting 901.1A here. The email address or statement in the email or message identifying the author is usually not sufficient by itself to authenticate the author's identity. A person other than the purported author may be using the email or Twitter account, or the email may be a spoof.
But the author testified that he is the one who was posing as the child. He was the one that was communicating. I mean, we don't have a case where we're going to say, okay, the author, we don't know who the author is, or we know who it is without that author testifying.
Right, Your Honor. The author of the messages that matter is Bonjay Roy. It's totally irrelevant what the officer, the messages that he authored, that's irrelevant. That's not probative of guilt or innocence. That's just, so what matters is the author of the messages on the other side of Bonjay Roy. And those Gmail addresses, and just so the record is totally clear, the email address that we have, it's not even from his email address. It's from a D9, B9, F7, et cetera, at reply.craigslist.org. That's not his email address. So even if you had his email address, according to Earhart at least, that's insufficient. But you don't even have his email address. You have some random email address, which sounds a lot like the spoof that Earhart was talking about.
Let's talk for a minute. Let's assume for the moment that your client is bound by the argument the defense counsel made below, that the phone actually belonged to his brother. I mean, I understand you dispute that, right? But for the moment, let's say that connection is there. What does that do to your argument here? That substantially weakens your argument, doesn't it?
No, I think it strengthens the argument.
Strengthens the
argument because it's not his cell phone.
But his brother didn't show up at the racetrack to have sex with the child.
His brother could have been setting him up, playing a gag, whatever. It's not his cell phone, so the presumption has to be that it's not.
Did your client argue that his brother set him up below? Was that part of the reasonable hypothesis?
He said that his reasonable hypothesis was, I didn't send these messages, and the reason why I fled from the scene is because I was smoking marijuana.
Why did he come back? What was the reasonable hypothesis for getting gas? Coming at the same time at the specific time to meet the 14-year-old girl, leaving, coming back for no apparent, and the second time for no apparent reason other than to look around for someone, which is what the evidence suggested, right? What was your client's reasonable hypothesis for that?
Well, first of all, he pumped gas, right?
No, that's not what I'm talking about. I'm talking about the second trip back.
Arriving there in the first place, so I'll take them piece by piece. Arriving there
Pumped
in the
gas,
first place,
fair enough.
He pumped gas.
He leaves,
Right.
comes back, parks, and does nothing but apparently looks around for someone. That's what so what was the second, well, why'd he come back? What was the hypothesis?
Well, for one thing, he smoked marijuana in the car. That's his hypothesis. He went there and he smoked marijuana. Whether that was a good idea or
Is
a
that
bad
why he
idea-
was looking around for someone?
Look, they said he was looking around for someone. I'm not sure whether
Well,
he
that was
or
the
wasn't.
evidence, right? The jury could have concluded he was looking around for somebody. So
Jury could have concluded
what's
that.
the reasonable hypothesis for coming back, parking, and looking around for somebody at the exact time that the 14-year-old girl's supposed to be there?
Well, he smoked marijuana. So that was his reasonable hypothesis of innocence. He was there and he smoked marijuana. So setting that aside, I'd like to point out a very important fact. This is a high volume, high traffic gas station. So it's not as if, to borrow an example from The Adventures of Tom Sawyer, meet me in the graveyard at midnight and don't forget to bring your dead cat, Huckleberry.
Well, he was instructed to go into the store and buy the person who was pretending to be the victim a bottle of water.
Right.
Is there evidence that that's what he did?
No, there's not. There's not evidence of that, and that's crucial, Your Honor. And another thing that's crucial here, if you look at the text messages, they say, "You gonna text me or whatever when you're here? I don't know what to look for." There's no text message when we get there. So that I think undercuts this argument that his presence there, standing alone, is sufficient to authenticate it. Typically what we do is we send a text message, "Hey, I'm at the movies. Are you here yet?" When you're trying to meet with someone, that's what you do. That's how people communicate.
Unless you're committing a crime. I mean, I don't know that you would do that if you're there to meet a 14-year-old girl.
Well, he's texting throughout.
I think
So-
it's clear he was nervous. I mean, when he was at the gas station, because he gets out. I mean, the law enforcement officer testifies he was acting strangely, like he was talking to himself, or
Okay,
and then he goes into the store, and then he leaves.
right.
But then he comes back. So, I mean, he's looking around or whatever. He's repeatedly asked the law enforcement officer whom he was corresponding with, "Are you a cop? Are you a cop?" I mean, it's
I dispute that he was corresponding with them. Setting that aside, somebody said that, "Are you a cop? Are you a cop?" I dispute it was him, so I would resist that premise. As for him acting strangely, I mean, I handled his sentencing hearing. The guy's got an 81 IQ. He suffered a massive traumatic brain injury. So there are other innocent explanations for a person acting strangely at the gas station. So there's that.
Was that presented to the jury? Did the
It was
jury
not
hear
presented
that?
to the jury. No, but it was presented to the sentencing court. So there are innocent explanations for somebody acting strangely. Look, I'd like to shift my attention to what the state could have done. Because we're not asking the state to do the impossible, and in the ordinary course, it's not even a heavy lift. Authentication does not require much. So they could have gotten a business record certification for the Gmails. What do? They just have something that, I mean, and
And
I'm
I don't
looking
want
at
to.
it
I
here,
don't want to
it's-
get you in mid-thought, but I want you
Okay.
to. If we were to determine that the trial court improperly admitted this evidence,
Mm-hmm.
is the remedy a new trial?
Well, we think that it should be, the trial court should honor its promise and it should grant a judgment of acquittal, because without this evidence, there's nothing to tie the defendant that he developed the requisite mens rea that he was traveling there for unlawful sexual conduct. So we think that the remedy should be what the trial court promised in the first place, judgment of acquittal. Having said that, look, I mean, we're the appellant here. Would I live with the new trial? I could live with that on appeal. But what I don't think is proper is to take all this, which is purely, I don't think that there's any jurisdiction, I've never found a case in Florida or any other jurisdiction where this would be sufficient to authenticate this evidence. Again, he shows up there, but a lot of people show up there. It's a gas station on the main drag there in Deltona. They chose it because it was a high-volume area.
How did this evidence, there's really three pieces of evidence, right? There are the emails, the texts, and the phone.
Phone call, right.
So at what point did the trial court admit those three things, and through which witness?
Okay, so the chatting was admitted through
I'm sorry, what's chatting?
the Gmail chatting, the
Gmail,
Craig's
okay.
list. That was admitted through, I believe, Aaron Kofer, who was the officer who was conducting the chatting. The phone call, which I'd really like to talk about because that's our strongest point on appeal, the phone call was through Detective Maynard. She was a sponsoring witness who, by the way, she said, I have no idea who the person on the other end of this call is. So that, standing alone, the phone call, easily sufficient for reversible error. Under Hernandez, which is binding precedent, I have no idea who the other person is on the end of the call. You know what? The jury asked for a playback of that very call. That was the primary evidence that the state relied on to argue that he was there for unlawful sexual conduct. So setting everything else aside, that phone call under Hernandez is reversible error.
And the text, excuse me.
If the other stuff comes in, how is the phone call not authenticated then?
Well,
Assuming the other stuff comes in.
If the other stuff comes into evidence, I still think each one has to rise and fall on its own.
Well, explain to me how, if the other evidence is proper, and you are into your rebuttal time, so do you want to?
I'll take a question.
If the Gmail and the text messages come in as properly, let's just assume for a moment, those are connected to the phone call. How is the phone call not authenticated? Just explain that to me.
Okay. The phone call, again, I think that each thing should rise and fall of its own accord. And the phone call number one, it's not his phone. Number two, Detective Maynard testified she has no idea who the person is on the other end of the phone call. And so I don't think that you can bootstrap.
The only way they got the phone number was from the emails.
That may be the case, from the text messages, which, by the way, were not properly authenticated in the first place.
No, right, but I'm saying if they were.
Assuming that they were properly authenticated, I think that you could make a credible argument. I still don't think it's proper, but you could make a credible argument that authenticated evidence, I've seen cases where they say authenticated evidence can be used to bolster the authenticity of unauthenticated evidence. But in this case, there was no authenticated evidence in the first place, so you can't bootstrap unauthenticated evidence using unauthenticated evidence to make all of it authenticated. Your Honors, I'd like to reserve.
Thank you. You have 3:25 left for rebuttal.
Thank you.
May it please the court, my name is Chris Davenport and I represent the state of Florida. First of all, just to clarify this, who the phone belonged to, on cross-examination of the lead detective in this case, the defense counsel asked him a bunch of questions about where he got these names from and how this all came in. And he said, we tracked the phone number back to a Roy. Defense counsel said, well, actually the phone number comes back to a different Roy, it comes back to Ron Roy. So defense counsel brought that up, and the detective said, I don't remember what the Roy's name was. It was a Roy. That's what I remember.
Well, this is really a red herring, isn't it? Because the case law across the country says that even if the defendant owns the phone, that's not enough. Isn't that
Right.
what the state of Mississippi and the state of Pennsylvania and the state of Kentucky and the state of Virginia all say?
Exactly, Your Honor. What's missing in here is the stuff that his case law complains about. We didn't bring in business records to show that it was his email account or his cell phone because that's not enough. What we did is we brought in extrinsic evidence that tied him to this particular conversation, which is what those cases require.
What is that extrinsic evidence?
It's the timing, it's all a bunch of pieces of the puzzle. It's the fact that the Gmail was a response to the Craigslist ad, which had the Bonjer Roy name on it. And that's, he talks about the email being a bunch of numbers. That's a Craigslist thing, so that you can't reach people outside of Craigslist.
But there's
you put a
nothing
name on there.
There's nothing in those Gmails that relates specifically to the defendant.
No,
to
it's
identify.
all a piece of the puzzle. You have to look at it in the totality. And again, that
If you don't
name
have
on there could
if you
have said,
if you don't have the notion that the phone belongs to the defendant's brother, you have a significantly weakened case then, right? Isn't that a significant connection?
I think it is a significant
And without
connection.
it?
I think without it, we still have enough.
All right, explain that.
But let me say, this came in on cross-examination. There's no objection to it. It's proper. He can't complain about it now and say that that doesn't count. He brought it up. The officer testified it was registered to a Roy. Well,
Well, the officer didn't say it belonged to his brother.
No, the defense counsel said that.
That was
But
counsel's-
So what we have from the testimony itself is that the last name of the person the cell phone was registered to was Roy, which just coincidentally happens to match the person who shows up at the gas station. So again, not enough by itself, but when you put it all together and it's all tied together, you can't look at it just individually.
The phone number to make contact with Roy
Right.
was given in the text messages, right?
Yes. And then they immediately called.
And there was decision during this conversation to meet at the racetrack.
Yes.
And coincidentally, somebody by the name of Roy shows up at the exact location where this is supposed to take place, and then, when confronted by the police, hightails it.
Exactly. You know, the timing of this is so precise. I mean, the last text message is sent at 12:35.
I mean, counsel,
He
other than
said,
the
"I'll be
running,
right there."
other than the running, I'd hate to be named Smith, right? There's a Smith that makes these, sends these text messages, and then a Smith shows up at a gas station that has a lot of traffic. Doesn't that seem problematic to you?
No, for a number of reasons. Number one, they selected it so that they didn't want this gas station in the middle of, nowhere, where they couldn't blend in to do their surveillance. There were three people at the gas station.
Other than the running, you have Roy, somebody named Roy with a cell phone, and then somebody with the last name of Roy shows up at a gas station. That doesn't seem like a real strong connection.
And a Gmail account that says Bonjay Roy, and an unusual name in Benjamin.
Yeah, the first name, right?
So we have that. Plus, we have the way that he acted at the gas station. He didn't just go in there and pump gas and leave. He was yelling at himself. He was acting very nervous. He went into the store. We would submit to buy the bottle of water the little girl had asked for. He didn't come out with one necessarily. We don't know if he got one or not, but he went into the store, which is, again, another piece of the puzzle. But he leaves and comes back and sits in his car and looks around.
Well, then
He's
that was
looking for
completely
someone.
contrary to the instructions in the text, that he did not buy a bottle of water.
But
when he went
again,
in there.
we're
He went in
talking
for
about
something else.
But we're talking about a very jumpy defendant here. So he was yelling, look, my interpretation of this was he didn't know if he should do this or not. He was afraid the kid was a cop, and he wanted to do it, but he didn't want to do it, and he was in a battle between good and evil within himself. That's what it looks like to me. But
That
be
sounds
as
like
it
a
may-
closing argument, not
Right.
what's in the record.
Right, but what's in the record is the ties to his name, the ties to his first name in the Gmail, his last name in the cell phone, arriving at exactly the time when they were expecting this perpetrator to arrive, acting very suspiciously, coming back, looking around, and then fleeing when he got caught. When you put all of that together, that shows that this guy was the person who sent the Gmail, and he was the person who sent the text, and he was the person who was on the other end.
What about counsel's argument that, look, he ran because he was smoking marijuana?
There's absolutely no evidence that there was a smell of marijuana at the gas station. They smelled marijuana in his car an hour and a half later with the windows down. So, I would submit that, the smell doesn't stick for an hour and a half. But there was certainly no testimony that they smelled marijuana at the gas station. And the police officer was right there and had him roll his window down and told him to stop. And the guy said, okay, and then he took off.
Okay, there was no testimony that he smelled it. Was there testimony that he didn't smell it?
No, there was no testimony either way.
Okay, so isn't it a fair inference from the strong smell of cannabis later that there was at least cannabis in the car at the time?
Perhaps. But again, he showed up at the exact time that he was supposed to meet this girl. He left and came back and started looking around. This is what they look for when they're picking up these guys, because they're used to this. This is not an unusual crime. He did exactly what they were looking for. Plus, we have the phone tied to a Roy. Plus, we have the unusual first name tied to the Gmail account.
Except he didn't text her when he got there, and he didn't go inside and buy a bottle of water. So it's really a stretch to say exactly, right?
He went in again, nervous defendant, going back
Okay,
and forth.
but we're not talking about that. You said he did exactly what the text reflected. That's a stretch, yes?
Put up exactly when they expected him to be there.
Okay, but he didn't do exactly what,
Not exactly.
Okay.
He did not reveal that he was there. He was clearly nervous about that. The last text was okay at 12:38, and then he arrived right around that time. So either texted when he got okay when he got there, but he never said, "I'm here now." Again, jumpy defendant. But we would submit putting all the pieces of the puzzle together. There is enough to authenticate that this was the guy who was sending these messages.
I'm not sure what this goes to, or does this go to authentication?
Yes.
Or the absence of a reasonable hypothesis of innocence, or both?
It goes to both. All of the pieces of the puzzle fit together for both of those issues. I mean, authentication, we just have to show that it is what we say it is. So we showed that by the people who were participants in these conversations saying, yeah, I looked at it, this is the conversation I had. We also had to tie it to the defendant.
Yeah, you said,
and
you
that's
didn't
how we
just say
tied it
this
to
was
the
a conversation I had. You said this is the conversation and we had this conversation with
the defendant. So
Right,
that's what tied it to the defendant. That's where the issue is does this tie to the defendant? And we submit that, given all of these pieces, it is enough to allow the jury to make that determination.
Counsel, let's assume for the moment that we conclude that, that the emails and text messages were not properly authenticated, and we reverse. What's the remedy? Is it a new trial?
I would say yes, a new trial.
Why?
Because it came in and the state isn't required to continue proving stuff after the trial court said it was sufficient. If the trial court had said this isn't sufficient, perhaps they could have called an analyst or someone else to make it sufficient. Because they weren't given that opportunity, it would be a new trial.
I have one last question. Did the defense properly raise the issue of a reasonable hypothesis of innocence and this being a purely circumstantial? You do agree it's purely circumstantial?
I do agree it's purely circumstantial.
Was the issue for the defense properly raised below?
They raised it in the JOA that there was a reasonable hypothesis of innocence. They didn't come up with this, the brother set me up thing. That was not their hypothesis of innocence. It was just, I was in the wrong place at the wrong time, and I fled because I was afraid of the marijuana. That was their hypothesis. They didn't specifically bring up the brother. If there are no other questions, we would ask you to affirm. Thank you.
Thank you, counsel. All right, counsel, take your time whenever you're ready. You have 3 minutes and 25 seconds.
Thank you, Your Honor. With respect to the telephone, there is no competent evidence, non-hearsay evidence, that this belonged even to a Roy. I think it's clear, and the trial court judge makes it clear. He said, I don't recall anybody talking about an email address. I don't recall anybody talking about a photograph. I think investigator Janau was about to say a photograph when a timely objection was made. So am I missing something? And previously he said, this is all hearsay, sustained. So there was a timely objection made to the introduction using...
But there was, during cross-examination at least, there was testimony that the phone was registered to a Roy.
But the source of that was hearsay.
But
There's
the
no
point
reason...
is there's not an objection.
What?
There's not an objection.
There was previously an objection.
Well, but the defense
To his own question?
elicited this information, and the police officer testified that it was registered to a Roy. He couldn't remember the first name, but a Roy. Right. And so that is evidence.
Well, I would make this point. That
you want us to disregard it.
The source is hearsay, right? And the reason why there wasn't an analyst there is, guess what? He moved to depose the analyst.
The source can be hearsay all along, but unobjected to hearsay is called admissible evidence.
Well, he did object prior to that.
But then he asked the question. I mean, you're not saying that he objected to his own question, right?
Right. But, okay, so even taking that as a given, it was not his phone. At the very most, it was his brother's phone. That's in the light most charitable to the state.
Or someone with the last name Roy.
Or someone, which is even more attenuoid than even to having it be his brother's phone.
Yeah, but I mean, how do you get past, I mean, Roy is not Smith. Roy as a last name is not Smith.
Okay.
It's, Johnson or something that's very common.
Mm-hmm.
I mean, how do you explain away all the other circumstances in this case.
There are no other circumstances. He
Well, the
showed up
first
at gas
name, I mean,
station.
the.
That's it. He
The
showed up
first
at the
name
gas
looks pretty
station.
close, right?
His first name is close.
There is no explanation in the record. It's not a certified record, but that in and of itself is, Earhart says it, that's insufficient. To have that Bonjay Roy, it's not even his email address. So we have no idea where that came from.
I know, but I mean, the jury could look at the fact that his name is Benjamin Roy and look at these emails, and we've got a Bonji Roy. I mean, I don't think it's, most people understand that Benji is a nickname for Benjamin. And you've got
There's no
Bonji
Benji,
Roy.
there's Bonjay.
Well,
And who
yeah,
knows
but I mean,
what- Who knows what that came from? And again, the reason why it's not enough is because there's a possibility that could be spoofed. It could be manipulated by law enforcement.
It
You
has
don't
to be
have
a
the protection-
reasonable possibility. I mean, it has to be a reasonable hypothesis of innocence.
The reason, well, I'm not talking about the hypothesis. I'm stuck on authentication here because I think that it wasn't authenticated. You look at Earhart, that's what he said. It's not enough. Even if it were sent from his email address, it's not enough.
But that's not all you have. You have all of these other circumstances.
None of which were properly authenticated. Again, we're not asking too much. The Smith versus State, the Supreme Court of Mississippi, they have a raft of different ways that you can authenticate these electronic
We are in
communications.
Mississippi.
None of them were present, though. Well, I would ask this court to write, if we're wrong, please write an opinion on this, because we need guidance, because the trial court seemed to think that it's enough to just trot out the law enforcement officer on the other end of the other communications.
Any other questions?
No.
Thank you, counsel.
Thank you.
Thank you.
Okay, and as
Very
counsel.
interesting case and well argued and briefed.
Yes,
Thank
very,
you.
very good job.